Welcome to yet another Transatlantic Currents by the Center on U.S. Politics and Power, Finnish Institute of International Affairs. I'm Charlie Salonis-Pasternak. I lead the center. Today's topic, Supreme Court, what's at stake for American justice and governance, is one I am certain many people have thought about generally, but also those Finns who are following this, thinking about our own current ongoing justice, rule of law, questions mixing with politics. None of you have come here to listen to me. I'm just going to give a few administrative notes and then hand it over to Leo Michel, who will actually be doing the conversation, the interview with our guest. After the first portion, as usual, we'll have hopefully plenty of time for discussion questions. Please write your questions into the chat from where I will then pick them up. The chat will also eventually be populated with a few documents that are relevant to the topic. Many of you probably know who follow Transatlantic Currents here. Leo Michel, he's a non-resident fellow at FIA. Pleasure to have him here again. Also non-resident fellow at Atlantic Council. He has been at the Office of the Secretary of Defense in NATO policy and nuclear or non-nuclear arms control, and has written a number of publications, again, from nuclear arms control as well as general NATO politics. But as part of our effort to get CUSP, the center to also look at more U.S. domestic politics that have an impact on not only the United States, but foreign affairs, foreign relations, Leo has strung together a number of Transatlantic Currents events which touch upon what would traditionally have been viewed as mostly domestic politics. And before we get started, just want to thank again the ERCO Foundation, who has funded generously CUSP for almost a decade and made, among other things, this series possible. Leo, take it away.
Thanks very much, Charlie. This promises to be a momentous week for the Supreme Court and indeed for the rule of law. In 2 days, the court will hear oral arguments in the criminal case of Donald Trump versus the United States of America. His lawyers intend to argue that he enjoys absolute immunity from criminal prosecution for what they claim were official acts during the final months of his presidency. The Special Counsel will argue that no such absolute immunity exists, nor could it be granted without violating fundamental tenets of the U.S. Constitution. Other significant cases are also before the court this week. Tomorrow, for example, the court will hear oral arguments in the United States versus Idaho. This will be the second abortion-related case heard by the Supreme Court over the past month, and the court's rulings could have serious, indeed perhaps draconian consequences for the legality and availability of abortion procedures across a large number of the 50 United States. The court's eventual decisions in the Trump and abortion matters could produce aftershocks that affect the outcome of next November's presidential and congressional elections, but longer-term issues are also at stake. The controversial nature of several Supreme Court rulings over recent years, instances of raw political maneuvering surrounding the appointment and Senate confirmation of justices, and ethical questions raised by the conduct of some of the justices have combined in a way that produces, according to opinion surveys, an alarming erosion of public respect for and confidence in the court's legitimacy. So a lot is at stake this week and in the weeks to come in the court's rulings. To lead us through this tangle of really the intersection of jurisprudence in the United States and politics, we're thrilled to have Professor Elizabeth, known as Liz Porter. She is professor of law at the University of Washington in Seattle She has a distinguished academic career, in addition to which, and it's important to keep this in mind, she worked as a clerk, that is, a top legal assistant for Justice Ruth Bader Ginsburg, who was particularly well known for her fierce advocacy for gender equality and women's rights on the Supreme Court. Welcome, Professor. Before turning, and thank you, by the way, for getting up so early in the morning, because I know you're in Seattle at this time. Before turning to the substance of the Trump and other cases, I wonder if you could just take a couple of minutes to describe the scene and procedure in the court when oral arguments take place. Can you say a little bit about what's taken place behind the scenes as the justices prepare to hear these cases? And at this point, Charlie, I'll ask that you put in the chat a couple of links for our audience. These are links to the Supreme Court's homepage. And one of these links, you can actually listen to the live streamed audio of the arguments that will take place on Thursday. Professor.
Well, a few things. First, just in case people in the audience are unaware of it, the Supreme Court has only, in the vast majority of cases, discretionary jurisdiction. So the most important thing, actually, arguably, about these cases happens very far prior to oral argument when the court decides to put one of these cases on its docket. That process is purely within the discretion of the court. They do it according to a rule where 4 of the 9 justices need to vote in order to grant review of a case. And when I was clerking, which was about a little over 20 years ago now, we generally heard between 80 to 90 cases each year, but that number has gone down to about 60 to 70 cases now. So one of the most important things in looking at the culture of the court and what's at stake is which cases and when they decide to choose. Once they, and I should say that as a law clerk, that was one of my main jobs. So the law clerks, there are 35 or 36 law clerks each year, 4 for each justice, although my Chief Justice Rehnquist, only had 3. And most of us worked in what we called the cert pool, the certiorari pool, which means that every week or two, we would get a stack of cert petitions. The court gets about 7,000 to 8,000 petitions a year. And one of our main jobs was to go through our portion of those cert petitions and write a memo to the full court, not only to our justice, but to the full court, according to a very kind of rigorous tradition. There were only certain abbreviations you could use. It had to be very brief. And the idea was to give the justices the information they needed to know in order to vote on certiorari, or at least, if not to vote, then at least which cases they should pull to look at more carefully. So we had to write a memo, and at the end of the memo, we had to say, I recommend, we had to kind of put ourselves in line, I recommend grant, or I recommend deny. So as a law clerk, I was involved, and all of us were involved in that process. And the tradition is that you become a law clerk in the very first years of your career. So I was not an expert in any of these things in particular. I was too junior to be an expert at anything. And I think that's one of the main sort of attributes in some ways of our legal system, is that we really embrace generalism in many different aspects of being a lawyer here. So I had no particular sophistication or expertise. And one of the things that happens is, for me, is that I got to see a snapshot, basically a year-long snapshot of everything that was kind of percolating through the country. So prior to oral argument being set, the court has decided to hear a case. Then parties will file merits briefs. So first they file petition briefs, then they file merits briefs. And at that time, there's basically an open door for other groups, interest groups, civil liberties groups, conservative organizations to file friend of the court briefs. So the briefing in some of these cases will be voluminous, because in addition to the parties' briefs, there'll be a wide range of briefs arguing every aspect of this. I have to say, what's been interesting to me about these recent Trump cases is that there's also, I've noticed a bunch of briefs of just people they're usually lawyers or their friend is a lawyer, and they're just like, I care about the Constitution. Here's what I think you should do. So, and then the law clerks, what we do is we, at least in my chambers, my Justice Ginsburg, wanted everything very clearly in writing. So we wrote a memo, and it was the same thing. Our memo had to reach a conclusion. And Justice Ginsburg would always say to us, well, if it's very clear, I don't have to agree with your conclusion. And I want to be candid that I never thought that was true. So I always tried to understand what my boss's conclusion would be and at least gesture to it. So then the justices will take their memos, they'll take their own preparation, and the law clerks by this time, right, we also know a bunch of things. And sometimes we're talking to the law clerks from other chambers about complex sort of procedural questions or legal issues. And then there'll be an argument at the court. The court is very rooted in tradition, even though the actual building it's from the 1930s, so it's not actually that old. But the days of oral argument are steeped in a kind of tradition. The justices go down to a special room, the robing room, to get ready for argument. They had to adjust that room when there were women justices because there weren't at first. And the law clerks, there's a place for the law clerks to sit along the side of the courtroom. We had sometimes, depending on if you get there early or not, you have obstructed viewing, which doesn't matter because there's only 9 justices, so we know everybody's voice. And then the court there's quite a bit of, I'd say, pomp in the actual arguments, which typically last 1 hour. I'd say Chief Justice Roberts has sometimes, for what he considers to be important cases, extended the time a bit. Chief Justice Rehnquist did not, that I can remember, at least my year. So you have 1 hour per argument. And it's only recently, I think since the pandemic, that we can listen to live audio of Supreme Court oral arguments. Prior to that time, most lower federal courts and most state courts have opened up their courtrooms even to cameras, and that has become the norm. And the Supreme Court, interestingly, given our long tradition of open courts in this country, the Supreme Court has maintained a high degree of non-transparency, I would say. That is slowly changing. There are still not cameras in the United States Supreme Court, which is probably why you've only seen kind of vague pictures drawn by courtroom artists of oral arguments. But now, really quite recently, we can hear what's happening in real time. In practice, we used to get transcripts of the oral arguments. That was the fastest thing one could get. And they did not indicate which justice made which comment. So they would have somebody like me, if they had one who worked at the court, go through and just basically make our best estimate of who said what. A small number of people can come and witness the oral arguments, but the court is not that big. So for blockbuster oral argument cases, there'll sometimes be lines around the block for those few public seats.
And it's my understanding that Donald Trump will not be in the courtroom physically on Thursday, and that, of course, is because he is on trial in a criminal case brought by the state of New York. Is that correct?
That is correct. He's not permitted to leave that trial, I believe, and then come back. Mm-hmm. And most of the time, litigants are not at the Supreme Court. I can see that he would definitely want to go to the Supreme Court for his own publicity reasons.
I understand. Let's turn to the substance of this particular case involving the former president. Why is this case before the Supreme Court at this time? And you can take a couple of minutes, please, but we would all appreciate if you could describe in your own words the major arguments being brought forth by each side in this case.
Well, before I start on the arguments in this case, I just want to tell you the legal background, what we do know, and then I'll kind of tee up how this case works. So Good. We know from earlier decisions of the Supreme Court that presidents can be required, sitting presidents and former presidents can be required to participate in legal process. So, for example, President Nixon was required to respond to a third-party subpoena. And although it was a third-party subpoena because he was an unindicted co-conspirator in the case in which this happened, it was, despite the fact that as a technical matter, it was third party, once he turned over tapes that demonstrated his complicity or his leadership of the scandal at Watergate, his career was finished. And the Supreme Court held that nevertheless, he, like everybody else, he is not a king, he is a president, he must participate in the legal process. So that was a criminal, and recently, President Trump argued the same thing in state court, tried not to allow his accounting firm to turn over his tax records in a legal process in the state of New York. So we know to some extent that presidents do have to participate in criminal process. We also know from Bill Clinton's time in office that sitting presidents do also, and therefore former presidents, have to basically show up, and they're eligible to be sued for civil claims that do not arise out of their presidency. At the same time, in a case called Nixon versus Fitzgerald, the Supreme Court held in, I think, 1982, that sitting and former presidents are immune from liability for civil suits that relate to or arise out of their official acts. So again, this isn't criminal suits. This is just the concept that otherwise presidents who have to make politically unpopular decisions all the time will be flooded with civil lawsuits. And really the question that the court has never answered, because it hasn't really been presented this way, is whether that principle of Nixon versus Fitzgerald, immunity from liability for civil claims relating to a president's official acts, extends at all into the realm of criminal liability. So that's, to me, what I see this question as being. And the president, unsurprisingly, the former president, believes that he is absolutely immune from criminal liability for all things that pertain to what he says, based on an earlier case, is the outer perimeter of his official acts. Unsurprisingly, the prosecutor's view is no immunity at all. And one of the things I find a bit frustrating about this case is I think the answer might be someplace in between. And that's important because one of the elements at play here is timing of this case leading up to the election. So to the extent that there's a remand for further determination of what's permissible and what's not permissible, just that timing delay would mean that this was not happening until the presidential election in November, very likely. I guess just to be candid, that's one of the things that's going on here is will Donald Trump potentially be convicted of a crime prior to the time of the election in early November? And I think, at least in terms of these federal crimes, that looks somewhat less likely with each passing week. The Supreme Court will hear oral argument this week, but they are likely to issue a decision only in late June. And the other thing I should say is the court appears not to want to make decisions that it views will come down one side or another on this electoral process. And that worry, that concern about interfering with voters' voices is likely to influence the way that it drafts the opinion.
So to address this important point about timing, I know that yesterday, the New York Times published an op-ed by Liz Cheney. Liz Cheney, for those who are not familiar with her, is the former Republican Congresswoman. She was one of the leaders for a long time for the Republican caucus in the House of Representatives. She became the chairwoman or the co-chairwoman of it's called the January 6th Commission. That's the House of Representatives Commission that investigated all of the events surrounding the January 6th insurrection. And she lost her seat in Congress as a consequence of her opposition to President Trump on this, former President Trump. She wrote yesterday in the New York Times that it cannot be that a president of the United States can attempt to steal an election and seize power, but our justice system is incapable of bringing him to trial before the next election 4 years later. So I think that tracks very much with your concern. And I won't ask you to predict the court's decision on this case, but could you say what you see as the 2 or 3 most likely outcomes? And could you say a little bit more about the importance of timing? Indeed, let's come back also to one question. Why did the Supreme Court even accept this case? Because you have a federal district trial judge here in the District of Columbia who ruled that, no, the president is not a king, so he's not immune from criminal case. The appeals court, which is the second level, second highest level in the land, had a very extensive decision where it explained all of its reasons why the former president should not have absolute immunity. So I suppose that I understand the Supreme Court could have simply said, it's been ruled upon and we agree with that. Do you think it was a legal decision or, frankly, a political decision for the Supreme Court to look at or relook at this case for essentially for a third time?
Okay, that's a good question. I have 1 or 2 responses. The first is that the court does not reveal its certiorari votes, and it takes 4 votes, which means that the motivation of those justices who voted to grant the case, 1, those motivations are unknown. We don't know which 4. And 2, they themselves, it could be more, right? But the minimum 4 could have different motivations from each other. So it could be that some justices took it because they feel as if this is a really important case, just as the Nixon cases were, and the Supreme Court should speak on it. There could be justices who voted to grant because they think the DC Circuit opinion was wrong, which I could talk about in a moment. But second, prior to the DC Circuit arguments, the prosecutor in this case, the special prosecutor, Jack Smith, actually sought Supreme Court review on an expedited basis, specifically to make sure that this could be resolved in the earliest possible stage prior to the election. What this means is that actually both sides on this dispute have urged the Supreme Court to decide this case and have said that it was very important. So in that sense, there's not a great argument on Jack Smith's part that this isn't important and it doesn't have to be resolved by the court, because he did actually make that argument earlier. I also just want to note that the panel of judges who heard the case below, they did write a 56-page opinion, and it's not a partisan panel. One of the 3 judges who joined this unanimous opinion is a Republican appointee who's very conservative. I think that they, and I largely agree with them, they find the president's immunity arguments infuriating, anti-democratic, and very wrong. And I agree with that. I agree with that. I do think the result is that their opinion is detailed and exhaustive, but somehow doesn't provide a simple rule. And that concerns me a little bit, even though I still think the president's arguments are not at all consistent with our democracy, our system of government, or Supreme Court precedents. I don't think it is. So I think largely President Trump will lose. I also want to note, and this is a sleeper thing to note, maybe because I'm a civil procedure person. So I just want to there is a funny amicus brief by some, I think, former judges and scholars that argue, and this is a very Supreme Court, very American thing to do, argue, well, actually, because of changes in the laws governing special counsels, Jack Smith, the special counsel, is not lawful. He should have been appointed by the president and confirmed by the Senate. He's an officer who should have been formally appointed, and therefore this whole thing has to start from scratch. The parties have studiously tried to avoid it. The DC Circuit put in a footnote, but in terms of potential off-ramps, sometimes the Supreme Court takes what I tell my students is kind of a procedural off-ramp. There is that little tiny sleeper bomb in the case. Likely nothing happens, but it's a bit unclear, actually. So I predict he loses, but the timing every week that goes by makes it less likely that something will happen prior to his nomination, at which point he'll have, if he's been formally nominated as the presidential candidate of the Republican Party, he may have some arguments about just reasonable timing of his case. These things are all unknown because we haven't confronted things like this before. And as maybe we talk about a little bit later, I think when we think about the legitimacy of the court, the weakest area, I think, of the court in some ways has been cases that are protecting the right to vote and protecting kind of democratic values. That's, I think, if there's a concern about the court, it's a concern that in these cases, it's a little bit too, these types, this broad category of cases related to democracy and voting, it's been a little bit too willing to leave things to the political process.
Well, and let me just get you to confirm this or ask if I'm correct here. Will the court's decision on this case, let's say it comes out, as many people think, it might come out not until the end of June. Will the court's decision on this case affect the special counsel's other case, which is a federal case against Donald Trump concerning his retention of classified documents at Mar-a-Lago, or the separate criminal cases brought by the state of New York, the one for which he's on trial now, and the state of Georgia, which is a criminal conspiracy, once again, to overturn the results of the election, but that doesn't even have a firm trial date yet. Will any of those three cases be directly affected by what the court decides in this case?
So my qualified answer is it shouldn't, unless the special prosecutor himself is unlawful. I don't know what happens then. Mm-hmm. If Jack Smith is somehow, that's like the sleeper question. But the classified documents case involves actions that Trump took after he left office, and that statutory scheme, it basically, President Trump is arguing he should be absolutely immune for actions he took while he was in office and retaining documents to which he was not entitled after his presidency for an extensive period of time, despite many increasingly strident requests for him to produce those documents, would not be an official act that he took as president. So he can argue he took all of them, the day he left, he took everything, but he would still have retained those documents afterwards. So, and I think that statute, that whole scheme is designed for all federal officials to preserve the confidentiality of the government. And I don't believe that the court would interpret it in such a way as to bar enforcement of that scheme going forward, which would have serious national security implications. The Georgia case and the New York State case should, as a technical matter, not be addressed in this case because the immunity from federal court proceedings and the immunity from state court proceedings might be different. However, that is not guaranteed depending on a broad ruling in favor of Donald Trump could have implications, particularly for the Georgia case, where he could argue he was acting, this is not true, but he can argue that he was acting officially when he did that. Mm-hmm. The New York case, for which there's been a jury seated, this is where he paid somebody in order to hide information about an illicit romantic affair that predated his presidency. That case does not involve actions the president took after assuming office. That is from actions he allegedly took prior to becoming president. So I don't think that should be implicated. And generally, the court has tried not to rule about federal and state courts at the same time. we have a doctrine of constitutional avoidance, and they've ruled for just the narrow thing before them. I will say, I think this court sometimes does not adhere to that. So,
in the interest of time, I'm going to set aside for now questions on this other very, very controversial case. In fact, there's one case that was already argued with regard to abortion and the availability of a widely used abortion medication that induces abortion. And there's the separate case of Idaho. If we have time, we can come back to it, but let's come back to, I'd like to come back to this key question of the court's legitimacy, because it does seem to be, according to a number of public opinion surveys, more and more problematic in the eyes of the American public. And I'll just briefly mention, this is my view. I'm not a lawyer, but this is my view of reading the articles about this. There appear to be four reasons. One is that the court has made a lot of contentious rulings over the past decade on abortion, on gun control, on political gerrymandering and voters' rights. There have been questions raised involving relationships between certain justices and some ultra-wealthy benefactors who would appear to have an interest, financial or otherwise, in cases before the court. There's a third issue as well, and that's the manner in which justices have been appointed by the president and confirmed or sometimes blocked by the Senate, especially over the past decade. And there's been increasing criticism of the lifetime appointments of the justices. And that perhaps this is just something that in the 21st century needs to be relooked at. So let's kind of wrap up our session, and let me ask you this general question before we go to the audience, and that is, how concerned, this is your perspective, of course, how concerned is the American legal community? And in fact, how concerned are the justices themselves, to the best we can determine it, by questioning of the court's makeup and its behavior? And do you see any practical movement towards some types of reforms that could address these issues that appear to be contributing to diminution of respect for the rule of law and traditional respect for the role of the Supreme Court?
Okay, well, that's a big question. So first, I just want to, I'd like to break it down a moment. We talk about legitimacy of an institution like the Supreme Court in categories. So first, we can talk about legal legitimacy. Is the court using legitimate legal or moral grounds to reach its decisions? That's kind of within the decision-making process of the court. And I think your democracy case-related observation fits within that bucket. But secondly, more broadly, there's a question of what we call sociological legitimacy. And sociological legitimacy is not exactly popularity, but it's tinging on popularity. What do average people think overall about the court as an institution? And you are correct that the Supreme Court is currently very unpopular. I looked yesterday, there's one site that can tell you kind of day by day, and 36% of Americans currently seem to have a favorable view of the court, which makes the court less popular than both President Biden and former President Trump, which is, I think, kind of remarkable in terms of low popularity. At the same time, I think sometimes we, as progressive, irate, frustrated attorneys, overestimate the impact of that. And I would say sometimes when we say there are legitimacy concerns about the court, which is being said pretty often, although I'd say this claim peaked about a year ago, kind of post Dobbs. There was a wave of discussion of legitimacy. Sometimes we're using legitimate to mean a variety of other things, like I really don't like them, and I really don't like that decision. And that is not quite the same as legitimacy. So I guess I just want to distinguish between legitimacy regarding their legal opinions, and then there is this cloud of ethical concerns that's really only about one or maybe two justices. And that has an eroding, maybe corrosive impact. But for good or for ill, I'm not sure that those concerns are very deep. I think some of the ways that the word legitimate is being used is just says, well, the court is no longer making decisions that I agree with on a kind of systematic level. And I'm empathetic to that argument on the merits, but I'm a little bit worried about the label of legitimacy.
Mhm.
Where is the danger, I think, again, is the court, for example, over the last decade, as you mentioned, has substantially cut back on the Voting Rights Act. It has declined to become involved with very, very gerrymandered, very, very skewed voting districts in different states, saying that this should be left to the political process. Its actions kind of in these cases with regard to not only Donald Trump, but there was another case heard 2 weeks ago or last week about another January 6th defendant, where it's questioning whether the obstruction statute should be applied to these people. So I think it's been a little bit, in my view, it's been weak in ways that are very risky in its decisions preserving democracy. And I'm putting aside for just a moment the case that was heard earlier this year and already decided that came out of Colorado, where the state of Colorado attempted to remove Donald Trump from the ballot, because that's just such an unusual sui generis situation that it would be hard to draw a conclusion only from that case. But once you put that case in line with these other cases, our Constitution does not explicitly have the right to vote in it. It's presumed to be a part of a Republican form of government, but I think the Supreme Court has been willing to put that into the hands of the political process. And my sense is it would like to continue to do that. And that, I think, is, for me, the concerning thing. Like, are we taking too many steps now toward undermining our democratic system? Things seem okay, but are we down a path?
Mhm.
So I guess I'm answering two different ways at the same time, which is to say, I think fundamentally the court is still proceeding along normal lines. And despite the media, there's not a significant tie between the word legitimate and what they're actually doing. But on a broader sense, and it's not just right now, it's over the past 20 years, I do think there are concerns about the court's understanding of the importance of its role in preserving and protecting voting rights.
Thank you. Charlie, let me hand it back to you so we can collect and pose as many questions as you can get in the time remaining. Thank you so much, Professor Porter.
Thank you very much. I'm happy to be
Sure.
here.
Thank you also very much for that. I have a few questions here. There's a question about presidential immunity, but there is a second question which ties more to what we've just been discussing. So I'm going to take that first. It's a rather long one, but the litigation faced by former President Trump is on several levels unprecedented. We can in that. It feels like from an outside perspective, the court has become ossified in the face of this unprecedented event. Certainly, if there cannot be a clear legal ruling on a president before he runs again, the wheels of justice revolve simply too slowly. So there seems to be a clear friction between due process, jurisprudence, and the political process, eligibility of candidacy. Could you speak to this theme a bit more? Is this a system failure of some kind? Does this mean the political and legal systems are just not agile enough to respond to a sui generis individual?
Okay, you can tell me if I'm hitting this my response. I think there's a tension in this question. On the one hand, if the court is ossified, we don't have term limits. The court is too insulated from any accountability on the one hand. That's a problem. But I think that problem, or that perceived problem, may influence the court to not get involved in what it considers to be things that are best left to the electorate, which is to say, I don't think it would be coherent of the court to be sensitive to its own role as 9 unelected people with lifetime appointments, on the one hand, and take aggressive action in this context, if that makes sense. And that tension is, I think, feeding the court's. The court understands that this question of immunity is very important. This is a huge case, unlike the Colorado case, which I think was important, but not structurally at the heart of the country like this case. And at the same time, they are keenly aware of people's perception that they are not elected, that they should not be manipulating the political process. And when I say they, it's again difficult to speak of the court as a single institution. Our court is made up of 9 individuals. They write separate opinions often. So they it's a superficial labeling. And of course, they're also not sharing their views. But this lack of term limits, this lack of accountability, this lack of transparency on the one hand, I think fuels an unwillingness to put their thumb on the scale in political battles. In addition, I think there's probably significant differences among members of the court, and they're maybe taking refuge in that theoretical reticence. Does that make sense?
Very much makes sense. And if I can do a follow-up before the next question. So I would imagine the Chief Justice, having become more aware in recent years, or at least publicly more aware of this, his role, place in history and all this, probably might even encourage, if the judges did not want to put their thumb on the scale, to say it's okay. We realize this is important, but for us and the court, we have enough things going against each other, including linked to a Pew study on the favorability of the court. And yeah, for the first time in a while, it's now less favorable than more unfavorable. Question, could we go back to the question regarding potential likely ways the court could rule on presidential immunity? I guess maybe more broadly also, although you said they tend not to want to do broad strokes.
I think they will broadly say the first line will be presidents are not absolutely immune from criminal process. I think it would be the reverse answer would be truly shocking, but the devil is in the details. So, for example, they might find that there is qualified immunity for certain acts taken by the president. This is true for state and federal officials broadly, and it's a little bit counterintuitive. Generally, there's immunity or qualified immunity, partial immunity for good faith efforts to make discretionary decisions. There's no immunity for what we call ministerial acts that you're required to do by law. And the court wouldn't have to decide, and probably almost certainly at this stage where we just have an indictment, would not decide how that applied. But there could be some, I don't agree with this, but I don't think it would be beyond imagination for the court to provide some protection for discretionary official acts of a president. And they would not decide in this context whether that applied to the charges in the indictment against this president. That would be resolved on remand, which would take time. In my view, there's very strong arguments that the acts that President Trump took were actions of an office seeker. They were actions of a candidate. They were not at all relating to his, neither Congress nor the Constitution, for good reasons, charges the sitting president at all with overseeing the integrity of the election, right, in which they're a candidate. So I think the facts are different from the general legal structure. And the court may not do that, but it may. And if it does that, what will happen? This will all have to go down and be sorted. And that will take time. And there could be another interlocutory appeal, right? This could go on, and then suddenly we're at November. This is unprecedented on both ends. It's unprecedented that the president would have done this, and it's unprecedented that despite having done this, the former president is once again a very strong candidate for national office. This reflects a very strange moment. This is maybe off topic, but I just want to note that terrible politics has been a long-term historical ingredient in our Supreme Court. Our most famous original Chief Justice, John Marshall, back in the early 1800s, he was Secretary of State prior to becoming Chief Justice, and he actually for a while held both offices, which now seems very unusual. And he had such a deep animosity for President Jefferson that it influenced everything they did. They truly did not like each other. Apparently, Chief Justice Marshall's mother had been asked to marry Jefferson and said no. I mean, we have a long history of quite tangled, unpleasant, personal and philosophical animosity between the court and organs of government, and at least we're still here.
I wholly subscribe to that idea, to remember also decisions regarding civil rights or other things where they are clearly political, but it just so happens that maybe they were on the righter side of history there. We have a few questions. Leo, you had some. I'm going to take one here. It's a long question, but it's tied to the legitimacy of the court and effectively the nomination process. Could you say a few words about it? Because it seems that, as the questioner points out, it has become quite politicized. Now, it has been for a long time. It's simply that now it's easier for us to tune into any Senate hearing. But if you can give a few reflections on this, that would be great.
The nomination process has truly become a media and sort of political circus. Again, I feel the same way about the nomination process as I do about the process for selecting cases to put on the court's docket, which is to say the selection of a candidate, bracketing the circus, is the most important thing. And the presidents who are selecting candidates that they know they can get through a Senate vote, however contentious, that is the moment, the vetting and selection prior to the media and the giant public nomination process. That is the moment that's tricky. I think we're in a polarized country, and you can see that what do people want Donald Trump to do? They wanted him to nominate candidates who would vote to overturn Roe versus Wade and eliminate the constitutional right to abortion. And he did that. And again, that is a broadly unpopular decision in the country with very strong support from a different part of the country. It is a deeply polarizing decision. But Justice Brett Kavanaugh had a sudden allegation of sort of sexual assault when he was a high school student come and temporarily blow up his nomination process. Otherwise, I would say now we watch it, we know what this process is. Americans have views, many, not necessarily informed, but they have views. And at the same time, it really just depends on how many votes you have in the Senate Judiciary Committee and how many votes you have in the Senate. That most of these votes will happen along party lines now. And what happens in between is more of it's not totally a show, but somewhat of a show, and an ability for those senators and the president to support their candidate by showing them in the best light.
Okay.
So it's been a mess, but I think the mess maybe disguises kind of the raw power that's behind the nominations.
Yeah. Leo, I'm sure you have a few questions. If I can just ask this one question that's still here. It's about the immunity case, and we're all familiar with the idea of swing states, although there are fewer and fewer of them nowadays. But the question is, who are the most important swing justices on the immunity hearing, and who should we watch for? Says that often we can sense hints of the court's rulings when we listen to the words they use in their questions.
I do think that we can often tell from the tenor of an oral argument how things will come out. Swing justices here, I'd say right now, the center of the court is the Chief Justice, John Roberts, Amy Coney Barrett, who was appointed by President Trump, and Brett Kavanaugh. They are the if you could call it the center, the quite right of center of the court. I think it would not be at all surprising for Samuel Alito and Clarence Thomas to broadly support the president and robust immunity, although we don't know to say this is this isn't necessary. Basically, it's not necessary to have this immunity for somebody who's already out of office. The danger is past, which is obviously not true. And I think the three more progressive justices, Justice Jackson, Justice Kagan, and Justice Sotomayor, will be horrified that this question is even being asked.
So if I may then, Charlie, and Professor, just so you know, it was a few weeks ago, FIA did a program that I think was quite well intended about looking at the abortion issue in the United States. And because of this other case coming up tomorrow, and as I said, because of the intersection here of law and politics so clearly, could you say just a few words, describe what happened, what the issue is in mifepristone, which is the medication I mentioned, and then also this different case, which will be argued tomorrow, of the state of Utah, involving the state of Idaho. I'm sorry, I said Utah. I meant to say Idaho. I believe it's Idaho. These seem to me to be very important cases, and I think just so the audience understands this, the Democratic Party is making the rulings and the Dobbs ruling, and now subsequent some of the more conservative state rulings on banning abortion to be a major political issue for the November elections. So could you just set the stage a little bit on these two cases?
So they're two quite different cases in terms of their substance. The first case, which the court heard argument in about a month ago and will presumably decide, I think could potentially even decide prior to June, involved whether the FDA had properly approved expanded access to mifepristone, the medication that's used for medical abortions. And this medication has been approved since 2000 for use. And then in 2016 and again in 2021, the FDA expanded access to make it easier. So for example, you could obtain it through a telehealth appointment. So this, and actually the original district court judge who is a very doctrinaire anti-abortion judge, eliminated all the way back to the year 2000, far beyond the statute of limitations. I guess I want to say two things about this case. One, and this kind of hinges back to legitimacy. One is that this is not a case in between the plaintiffs who brought it are emergency room doctors, and they're alleging that they may in the future have to stabilize somebody's health by completing an abortion that had been begun with mifepristone against their beliefs. There's not any cases. There's not an actual person. It's a claim that this could happen, and there are long-standing federal statutes that protect doctors from having to take medical action that contradicts their conscience. So the likelihood of that is very low. So because of this, and because of another factor that I can't forget, I want to mention in a moment, I think the court will take a procedural off-ramp here. It will decide that these particular plaintiffs don't have a sufficient stake in this case for it to qualify under the judiciary's definition of what an adversarial case is, a case or controversy, a constitutional case is in our system. So I think the court will answer this question by not answering it. They will rule on the basis of standing to sue, and it will be maybe there'll be some details, but a fairly, not entirely, but strong majority of the court will take that procedural off-ramp. I just want to also note on that topic, one of the defendants in this case, the primary defendant was the FDA. And there are obvious problems with asking the court to, in the context of one case, cherry pick FDA activity and question its approval of drugs.
That's the Federal Drug Administration.
Correct. Excuse me. Thank you. And the other party in that case was the pharmaceutical company that manufactures this drug. So the court had before it a major representative of a major industry. And although we're not discussing it today, I think one of the most important qualities of this Supreme Court, and one that lends it a deep legitimacy in ways that maybe everyday Americans don't see, is its commitment to the business community. Above everything, I see this as a pro-business court. And the presence of a significant pharmaceutical company on the other side is perhaps a soft factor, not a factor that would be recognized, but is definitely a factor. And I think that this pro-business outlook is something else that is stabilizing the court in ways that we don't appreciate in some of these more social issue cases. The Idaho case is quite different, because in the Idaho case, they're looking at whether it's a conflict, it's not a manufactured conflict, I guess. It's a conflict between Idaho law and federal law. Idaho law says no abortion, unless the mother is threatened with death. Federal law says you can't wait till somebody's on the verge of death before providing an abortion to stabilize that pregnant person's health. And I would just say, I think the court's going to, usually federal law is supreme. That's the standard rule. The Idaho statute is very extreme. And what's interesting and complicated about it is people who present at the hospital who may require abortion aren't people who necessarily were seeking an abortion and it went wrong, but people who in fact were desperately trying to be pregnant and they had some kind of serious medical emergency. And that those facts may also influence this view, like what will happen to women in Idaho who are carrying children and have some sudden medical event. So it's a different political valence. I haven't heard the oral arguments, but that is a hard case. Typically, the federal statute displaces the state statute, and it'll be interesting and complicated to see the court make an effort to let these two things coexist.
Thank you. Back to you, Charlie.
All right, I see one more question. We have a few more minutes, so we have time to take this. So the lifetime nomination was discussed. This might turn very political. In Europe, discussion has emerged on the example of Poland, where the government has tried to lower the retirement age of justices in office. This might lead to limit political maneuvering and impacts on rule of law. Any thoughts on whether or not Supreme Court justices should retire when everyone else does too?
Well, many Americans no longer can afford to retire, so
Fair
I don't
point.
think it's necessarily so out of step. I plan to teach till I'm 90, and I used to live in Poland, so I've been following what's happening in Poland quite carefully. For us, lifetime tenure with no lowering, with no diminution of salary is baked into the Constitution. So for us to change this in a serious way would require a constitutional amendment. President Biden, in the wake of Dobbs, commissioned through an executive order a committee to analyze potential reforms to the Supreme Court. So this whole group of judges and academics who studied these questions. And I want to say it's a very long report, but the basic result is,
Don't touch it.
You could try to change the norms of retirement, but that hasn't happened. You could actually have the Supreme Court justices, the best argument is to have them take turns working at lower courts. So you're shuffling the composition of the court, but then that would be itself so political, it might cause problems. You could increase the number of people in the court or decrease it. You could pack the court or try to shrink the court. In our country, given the constitutional protections of judges, they could only be removed from office through impeachment. It's a tough road. People right now are talking about the retirement of Clarence Thomas, who's the oldest, the only justice who was there when I was there. He's 77. And also of Justice Sotomayor. There's concern that just as happened with Justice Ginsburg, Justice Sotomayor is younger than Clarence Thomas, is not in perfect health, has had type 1 diabetes since she was a child. And there's been some pressure on her recently to retire. And as of now, there's no indication that she will. Justices do often announce their retirements at the very end of a term, but I don't necessarily see that happening. So I agree with you that it's a problem. I agree that having the same people in place for decades perhaps gives too small of a group of people too much influence over the everyday lives of Americans. But unfortunately, we seemed to have designed it that way. We were looking for stability, maybe not quite this amount of stability.
Mhm.
Well, and I think that's a fair argument too for anyone who studies politics, is to try to balance between having regeneration and then stability that goes across any political election or other such things. So certainly, and there's the argument that I remember asking a Afghan representative years ago whether or not the Afghan constitution should be opened to improve women's rights, and she said, absolutely not, because there's a likelihood that it was going to get worse. So, kind of keeping an
change.
imperfect but functioning document was, in her mind, much better.
We have to hope that this is also true in our situation.
So, but with that, apologies, run a few minutes late, but mainly, if I can ask everyone to get a virtual set of applause to Professor Porter. Thank you very much, Liz. This has been deeply insightful, both the broad perspective, your personal experience, as well as then being able to go what in US terms would be inside baseball or inside the Supreme Court. So thank you very, very much. And with this, the webinar is closed. Thank you.
Thank you.